The retirement file that secretly transferred your partner's entire nest egg to someone they divorced decades ago. Stop what you are doing immediately. Exit the other screen. Turn your phone over because the information you are about to hear during the next several minutes reveals the most financially destructive, most emotionally crushing, most intentionally ignored legal trap buried inside America's retirement system today. And the most alarming detail of all, it may already be sitting inside your desk drawer right now. Fully loaded, safety already removed. Picture this moment. The memorial service has ended. Friends stopped bringing meals days ago. Your children already returned to their homes in different states. You are seated alone at the kitchen counter in a home that suddenly feels painfully empty. You are trying to do what every practical, responsible, grieving husband or wife attempts after losing someone they loved. You are handling paperwork. You are organizing documents. In one hand is the death certificate. In the other is the carefully prepared last will and testament. Your lawyer created it in 2019. You spent $2,000 having it drafted. Your goal seems simple. Move the $1.2 million retirement account into your own name so you can continue paying the mortgage, handle property tax bills, and keep the household running through the next 25 years of your life. Statistics say you will probably spend those years alone. You enter the investment office. You lower yourself into the leather chair across from the advisor who has known your household for over a decade. He gives you that practiced, sympathetic smile financial advisors rehearse endlessly. Then he rotates the computer monitor toward you and suddenly his expression changes. The professional mask slips away. The smile disappears and he quietly says 7 words that instantly destroy your financial future. Ma'am, your name is not listed here. You actually laugh because obviously your name should be there. You shared 26 years of marriage together. You raised 3 children side by side. You are holding the will in your hands. The will clearly states, 100% of all assets and possessions, including retirement accounts, shall pass to my beloved current spouse. The advisor looks directly at you and says the second sentence. The sentence that permanently changes your life. Back in 1992, years before the two of you ever met, your late husband completed a single beneficiary designation form for his retirement account. He listed his first wife. He never changed it afterward. Under federal law, specifically the Employee Retirement Income Security Act of 1974, that form has complete legal authority over every will, every court judgment, every divorce settlement, and every assumption a spouse may have. The will means absolutely nothing. The transfer was processed yesterday. Yesterday, during 45 seconds inside a leather office chair on a quiet Tuesday afternoon, 26 years of marriage were financially erased because of one document completed during the George H.W. Bush era. This is the ex-spouse payout disaster, and it destroys thousands of American families every month. This is not some isolated nightmare. Somewhere in Dayton, Ohio, a widow is signing these same papers right now. Somewhere in Tampa, Florida, another widow is learning the money already disappeared right now. Somewhere in San Bernardino, California, a widow is calling her adult son asking how she will afford her mortgage payment this October right now. And the estate planning industry, the attorneys charging grieving families thousands of dollars for elaborate plans placed inside expensive binders, rarely explains this danger clearly. They do not place this warning on the front page. They prepare a will, shake your hand, validate parking, and send you home believing everything is protected. Meanwhile, in actual legal and mechanical reality, you remain completely vulnerable. The legal system does not care about your relationship history. It does not care that your marriage lasted 26 years. It only recognizes the name typed on line 4 of an old HR form hidden in a corporate database that has changed ownership several times since the document was first signed. The 3-part trap. How this financial catastrophe is built. Understanding exactly how this system operates mechanically is the only way to defend yourself before disaster strikes. There are 3 separate layers. Every layer was created, structured, and federally enforced to guarantee the person named on the outdated form receives the money. Layer 1, the non-probate asset loophole. This is the foundation of the entire problem. This is the uncomfortable truth hidden deep inside the fine print. Under American estate law, your property exists in two entirely separate legal worlds. Two worlds that never interact, never exchange rules, and never overlap. World number one is known as the probate estate. This world is controlled by your will. It includes items like a checking account solely in your name, your vehicle, and personal belongings. After death, the will is submitted to probate court. A judge examines it. Creditors receive notification. Then, after months of legal delays, court supervision, and attorney expenses, the remaining property is distributed according to the instructions in the will. Inside this universe, the will rules everything. World number two is called the non-probate estate, and this universe follows completely different laws of operation. Here, the will effectively does not exist. The probate court has no authority whatsoever. The executor cannot interfere. Assets transfer automatically by operation of law, meaning the contract currently stored at the financial institution becomes the only document with any legal value. The contract identifies the recipient. The money moves instantly. The will is never reviewed. No attorney is contacted. No judge becomes involved. The brokerage firm, insurance company, or pension administrator simply checks the form, reads the name, and sends the funds. Finished, finalized, complete. Which assets exist in this second universe? Almost every valuable asset most Americans own. Your 401k, your IRA, your Roth IRA, your 403b, your 457 plan, your pension account, your life insurance policies, your annuities, every payable-on-death bank account, every transfer-on-death investment account, and every jointly owned property. For most retirees in America today, this second universe contains roughly 80% to 95% of their entire net worth. The will, the document you spent thousands preparing, controls only the remaining 5% to 20%. Read that carefully one more time. Your will governs only a minority of your wealth. The majority of your assets are controlled by forms you may have signed decades ago, sometimes before the Soviet Union collapsed. Then comes Layer 2, the ERISA federal override. This is where the situation becomes explosive. This is where even state law and divorce judgments become powerless. The Employee Retirement Income Security Act of 1974, commonly called ERISA, is the federal law regulating nearly every private sector 401k, 403b, and corporate pension plan across the United States. Section 514 of ERISA contains one of the strongest federal preemption clauses found anywhere in American law. Section 514 declares that federal ERISA rules override and replace any state law related to employee benefit plans, every single one of them, including state probate laws, including state statutes saying divorce automatically cancels beneficiary designations, naming former spouses, including court orders signed by divorce judges clearly stating an ex-spouse surrendered all rights to retirement money. In 2001, the United States Supreme Court ruled in Egelhoff versus Egelhoff. Washington state had a law saying divorce automatically revoked beneficiary forms naming a former spouse. Mr. Egelhoff divorced and died 2 months later without changing his paperwork. His form still listed his ex-wife. His children argued Washington law canceled the designation. The Supreme Court ruled 7-2 that ERISA overrode Washington law. The retirement plan administrator had to pay the person named on the form. The ex-wife received the money. The children received nothing. Then, in 2009, the Supreme Court ruled in Kennedy versus Plan Administrator for DuPont Savings and Investment Plan. A divorced man's former wife signed a legal agreement surrendering all claims to his retirement savings. He later died without updating the beneficiary form. His daughter sued for the money. The Supreme Court ruled unanimously 9-0 that the plan documents controlled everything. The form stored on file was the only document the administrator could legally consider. The ex-wife received the money. The daughter received nothing. This is not an accidental flaw. This is the intentional, federally structured, Supreme Court-approved design of the American retirement system. The administrator at Fidelity, Vanguard, Empower, or whichever institution manages the account is legally prohibited from interpreting your will. They cannot examine your will. They cannot consider the divorce settlement. They cannot weigh the reality of your marriage. They may review only one thing. Whoever appears on the form receives the money. Layer 3. The divorce decree illusion. This is the stage where many attorneys realize they never truly fixed the problem. A husband and wife divorce in 1995. During the settlement, the judge signs an agreement. On page 31, paragraph 14, the document clearly states the wife waives all rights to the husband's 401k now and forever. Both parties sign it, the judge signs it, the court finalizes the order. Everyone leaves believing the issue is resolved permanently. It is not resolved because the state court judge has no authority over the ERISA retirement plan itself. The judge cannot force Fidelity or another administrator to remove the former spouse from the beneficiary designation. Only the account holder personally can do that. He must access the account, submit a new form, and officially replace the old beneficiary designation. If he never completes that step, the previous form remains legally active forever. Federal law overrides the divorce order completely. The ex-wife continues as beneficiary. 26 years later, the husband dies. His current wife arrives carrying the divorce paperwork. The plan administrator has never even seen it before. They only have the beneficiary form. The form still names the former wife. They send the money to her account immediately. The real-life financial destruction. Actual figures. Actual consequences. Concepts alone do not motivate people. Real numbers do. Here is the full financial breakdown of this disaster, using a documented composite example. John is 68 years old. He spent 32 years working for an aerospace company in Southern California. He was married to his first wife, Linda, from 1988 until 1995. In 2000, he married Sarah and remained with her for 26 years until dying suddenly from a heart attack. On paper, John's estate appears straightforward. Personal checking account in his sole name, $100,000. 401k from aerospace employer, $1.2 million. Employer-sponsored life insurance policy, $500,000. Roth IRA with updated beneficiary completed in 2002, $150,000. Joint checking account shared with Sarah, $50,000. Family home jointly owned with rights of survivorship, $800,000. Total estate value, $2.8 million. John's will leaves everything entirely to Sarah. Now watch what truly happens. The house transfers automatically to Sarah through joint ownership. Sarah receives $800,000. The shared checking account transfers directly to Sarah. She receives $50,000. The Roth IRA beneficiary was updated in 2002, so Sarah receives $150,000. The sole checking account enters probate court. After legal fees and costs, Sarah receives roughly $85,000. However, the 401k established in 1992 still lists Linda as the primary beneficiary from the original employment paperwork. The plan administrator wires $1.2 million directly to Linda. Sarah receives nothing. The employer life insurance policy issued in 1993 also still names Linda. The insurance company mails Linda a check for $500,000. Sarah receives nothing. Final distribution results. Sarah, the wife of 26 years, receives $1,085,000. Linda, the ex-wife John had not spoken to for more than 3 decades, receives $1.7 million. More than 60% of John's total wealth went to a woman he divorced during the Clinton presidency because of paperwork completed during the first Bush administration. Sarah, now age 66, will probably need to sell the family home within several years just to afford healthcare expenses and daily living costs. Linda schedules a vacation cruise, the hidden loophole the industry avoids discussing. When most people hire an estate planning lawyer, the process usually unfolds the same way. The lawyer asks for a list of assets. The lawyer prepares a will and sometimes a revocable trust. The lawyer charges somewhere between $2,500 and $7,000 depending on location. The documents are placed inside an attractive leather binder. You leave the office believing your family is safe. Here is what probably never happened. In most estate planning cases across America today, attorneys do not require clients to sign into employer HR portals, brokerage websites, and life insurance accounts during the meeting to verify current beneficiary designations, compare them against the new estate plan, and update everything immediately. They prepare documents. They do not synchronize the forms. They send clients home carrying beautifully written paperwork that has no control over the majority of their assets. Why does the industry function this way? Attorneys usually cannot directly access corporate HR systems. Updating beneficiaries costs nothing and creates no billable hours. Drafting legal documents does generate revenue. The financial incentive rewards drafting, not auditing. So outdated forms remain untouched. The future disaster becomes permanently embedded in the system. And the widow in Tampa discovers the truth one Tuesday afternoon while sitting inside a leather chair. The 4-step audit system that prevents the entire nightmare. This checklist costs absolutely nothing. It requires about 90 minutes of your time. It may be the single most important financial task you complete this year. Step 1. Create a full inventory of every non-probate asset you own. Take out a legal pad. Write down every retirement account from every current and previous employer, every traditional IRA, every Roth IRA, every 403b, every 457 plan, every annuity, every life insurance policy both personal and employer provided, every payable-on-death account, and every transfer-on-death investment account. If you cannot find an old retirement account from a former employer, search the National Registry of Unclaimed Retirement Benefits or contact the Pension Benefit Guarantee Corporation. Locate every account. Ignore nothing. Step 2. Sign into every account portal and personally read the beneficiary designation currently on file. Open the beneficiary section. Record the primary beneficiary, the percentages assigned, the contingent beneficiary, and the date the form was last updated. Most people are shocked during this step. More than half discover at least one outdated beneficiary designation. Former spouses, deceased relatives, estranged family members, paperwork completed before remarriage, paperwork completed before grandchildren were born. Record every inconsistency carefully. Step 3. Update every form immediately. Update every single document, including forms that already appear correct. Submitting a fresh form creates a new digital timestamp, confirming your present intentions clearly. Use full legal names, include birth dates, include social security numbers whenever requested. Important ERISA detail. If you are married and choose to list anyone other than your current spouse as primary beneficiary on a 401k or pension plan, your spouse must sign a notarized spousal consent waiver under the Retirement Equity Act of 1984. Without that notarized signature, the plan administrator generally defaults to paying the spouse regardless of what the form says. This protection applies only to ERISA-governed plans, not IRAs. Step 4. Coordinate every beneficiary form with your estate plan. Bring your attorney back into the process and ask one direct question. Have you reviewed every beneficiary designation connected to my retirement accounts and insurance policies? And have you confirmed in writing that they match my will and trust documents? If the attorney hesitates or dismisses the issue, locate a specialist who performs formal beneficiary audits as part of every estate planning engagement. Those professionals exist. Demand the service. The legacy 401k danger. One final warning for anyone whose career began during the 1980s or early 1990s. Your first employer has probably merged, dissolved, or been acquired several times since you worked there. Your retirement account may have moved through multiple plan administrators. Your beneficiary designation may have been manually transferred from an old paper form into a modern digital database during one of those transitions. Mistakes happen constantly. Names are misspelled. Contingent beneficiaries disappear. Sometimes the original signed document still exists only on microfilm inside a storage warehouse somewhere. Contact the current administrator. Request a written copy of the beneficiary designation currently on file. Do not accept a verbal confirmation. Get the physical document. Hold it. Read every line. Verify every detail. Update it immediately if necessary. The administrator will never proactively warn you about mistakes. The system was designed to execute the form on file, not to protect your loved ones. You must become the auditor yourself. The final warning. If you are older than 55 and you have experienced divorce followed by remarriage, stop immediately. Walk directly to your computer. Sign into your retirement account right now. Check the beneficiary designation. Do not finish this video first. Do not make lunch. Do not promise yourself you will handle it tomorrow. Right now, stop reading. Walk. Log in. Check. Either the form is correct, meaning you gain complete peace of mind, or the form is wrong, meaning you may have just saved your spouse from total financial devastation. There is no third possibility. There is no scenario where reviewing the form wastes your time. The system will never review it for you. Your lawyer will not automatically review it for you. The plan administrator will not review it for you. The beneficiary form on file controls who gets paid. Make certain the form reflects the life you live today instead of the life you lived during the Gulf War era. Audit the forms. Protect your partner. Preserve your legacy. The opportunity to fix this still exists right now. Go use it. Nothing presented here should be considered legal or financial advice. Estate planning laws differ depending on state, asset structure, and personal circumstances. Speak with a licensed, board-certified estate planning attorney in your state for advice tailored specifically to your situation. ERISA regulations and IRS retirement account rules remain subject to change.